Welcome to Absolute Trust Talk with your host, Kirsten Howe. Absolute Trust Talk brings you tips, tools, advice, and interviews to help you build a reliable knowledge base on estate planning, business, and finance to start preparing for your future today.
Over the weekend, we heard that Jay Leno has filed a petition for conservatorship over his wife, Mavis Leno's estate. Madison, where did we hear about that?
I'm pretty sure it was Facebook. TMZ broke that as per usual.
Okay. So when I say we heard, what I really mean is Madison heard and she told me about it. I am not normally getting information from Facebook, but it's a conservatorship proceeding, which we don't normally do. However, the case really is about estate planning. And so we wanted to talk about it this morning. I'm Kirsten Howe. This is Madison Gunn, and you are watching and listening to Absolute Trust Talk. Madison, tell us the particulars of this case and maybe a little more about what conservatorship really means.
Yeah. So conservatorship is typically if somebody doesn't have any type of document in case they're incapacitated, a family member or a close loved one can file to ask the court's permission so that they can either manage finances or medical care for somebody who's incapacitated. In this instance, Jay Leno and his wife Mavis did not have an estate plan, and she has dementia and is incapacitated, and he is asking the court for a conservatorship. However, it's not to manage her finances or medical care because he's already doing that without any issues, but he's asking the court special permission so that he can set up an estate plan for both of them.
Okay. So presumably if he's appointed conservator, he will be able to ask the judge to allow him to write an estate plan, actually for both of them. But the issue is, can he write an estate plan for her? Because normally you're the only person who can write your own estate plan.
Yes.
Okay. Now, my understanding, they've, as you said, they've been married for a long time. We know they don't have children. If she were to pass away, he would inherit everything if they don't have an estate plan. If she has no will, no trust, he is her heir. So why is he so concerned about this?
Yeah, the bigger issue is not what happens if she dies, it's what happens if he dies first. So, that's fine. I'm sure he would like everything to go to her. So we'd like everything to go to her. But the problem is, who's going to manage it? She's already incapacitated. I'm sure they would like to choose who's going to manage the finances. He would like to choose who's going to manage the finances for either of them on incapacity, rather than having anybody be able to step forward and file a subsequent conservatorship over her to manage her finances. He's managing their joint assets. If he dies first, they all become hers. A conservatorship would be required. So that's the bigger concern. And he's gotten into car accidents in his lifetime. He loves cars. So there's a distinct possibility that could happen.
Right. People with dementia, first of all, can live a long time. That's not necessarily a death sentence. And there's no guarantee that he's going to outlive her. And even if he does outlive her, what if he loses capacity? Then they're both in a pickle. He's doing this to protect her from outsiders who might not be as loving as he is. Okay, so this is not the way that we normally do estate planning. It certainly isn't ideal. Madison, what do you see as some of the problems with this approach to estate planning?
Right. So one of the things we always espouse usually is that crisis planning is way more expensive than preventative estate planning. So in this case, he's filing for a conservatorship. Then there's another step in order to get a estate plan written. Then he has to get that approved by the judge. So it's 3 or 4 filings, which is 3 or 4 times the cost. Plus conservatorships are just wildly more expensive than even just a probate typically over time. So it's a much bigger undertaking than if they had just set up an estate plan.
Yeah, there's more court process, more attorneys involved.
Yeah, it takes a lot longer.
Yeah, and it takes a lot longer. Yeah. Another thing that I see is the lack of privacy. You told me about this and I said, okay, let's read the petition. And you immediately went and found it on the court's website. That's not private. So we read the petition, which doesn't have a whole lot of information in it, but there are other documents.
Anytime you file for a conservatorship, you have to get what's called a capacity declaration. So Mavis would have been brought to a doctor. The doctor would have had to fill out a form and they have to file that with the court, and it's not confidential. There are other confidential documents that get filed with a conservatorship. The capacity declaration is not one of them. So I could have downloaded that and read the nitty-gritty details of her dementia. I chose not to because it's not relevant for what we're talking about. But, people don't want that out there. I'm sure if it was Jay Leno incapacitated, he would not want, I'm sure they would print that. I'm sure blog would print that.
Sure. Yeah. Yeah. You got to believe that that would happen. Okay. And so the other thing, the lack of privacy is also an issue when it comes to the estate plan. So normally our clients, they come to us, we plan it out together, and nobody sees it or knows about it until after somebody passes away. It's done privately.
Yeah.
This estate plan is going to be submitted to the court for the judge's review, for the other attorneys involved in the case to review, and possibly that's going to be on the website as well. So, here's Jay Leno putting his estate plan into the public domain. And that's not what most people would want either.
No, I mean, I think it opens it up for people to come out of the woodwork and say, Mavis promised me something, or, I'm her best friend in the whole wide world and I should get some money, but I haven't talked to her in 50 years. It's just all the crazy things that you see in estate planning that could pop up. Now there's a public chance for that to arise. Whereas with a trust-based estate plan, nothing typically gets recorded. There's nothing that gets filed, and we've talked about this before, with other celebrity situations. We're like, why did the probate arise out of that? Let's keep that private.
Keep it private. So, yeah. And not even just the lack of privacy, but the possibility that other people are going to comment and say, well, I think it should be like this. Yeah. Nobody should be allowed to say how your estate plan should be except you. Yeah. But they have to open it up to other people to come forward, possibly people who don't have their best interests at heart.
Right.
I guess the last thing that maybe bothers me about this also is that we don't really know, he has to write an estate plan for her based on what he thinks she would want. That might not be what really she would have wanted. I'm sure he'll do his best.
Yeah, there's always the possibility that she hasn't communicated something to him at some point during their marriage that she felt strongly about, wanting to include a charity or a person or what have you, jewelry to her best friend, something of that nature that he just didn't know.
Yeah, so that's not ideal. Okay, so the bottom line message here, Madison, what would you say?
Is to get that estate plan done. And we encourage this of our own clients, but in general, even if you don't know all the details, you can still get it done and then make updates later. So if you are like, I want to, provide for my children and avoid probate, avoid conservatorship, that's great. If you're like, I'm on the fence about including my grandchildren or a charity, let's just get started and get it done. And then you can make that change later. You can always change your estate plan until you lose capacity. And then this happened. And then even then, that doesn't mean they're going to make change just because you're incapacitated. That's not typical, but you at least want to have something in place.
Yeah. The good and done is better than perfect in your head.
Right. Yeah. It's fluid. Things change and we totally get that. But there were basic documents that could have been placed that would have avoided this conservatorship altogether. Yeah. Yeah, exactly. Okay. A very unfortunate but interesting situation. Thank you, Madison. And thank you all for joining us. I hope you learned some valuable lessons and, also were a little bit entertained. And we look forward to connecting with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcouncil.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcouncil.com/scheduling. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcouncil.com. Thanks again for listening. We'll see you soon.
This podcast is not meant to take the place of legal advice from an attorney and does not create an attorney-client relationship. If you do have a legal question or issue, please consult with an attorney.